Yes.
The two, okay,
Yeah, there were two emails. One where you assigned us cases, and then one where you shared with us the cases we reviewed last week.
oh, no, I only got the cases that was reviewed last week. I didn't get any new cases, I'm sorry.
Oh,
Yeah, I only got the ones from the one we did last week with Wendy's and Odyssey. I didn't get anything else.
oh, and I did try to find the first case with Wendy's, but I couldn't find it on the tribunal site.
Okay, well, that's the only one that I got.
Okay, can
From Mr. Pratt, right? I think it is.
yeah, can
Yeah.
someone send Samantha
Please.
cases? Would be very helpful. Let me know when you get it. Oh, where did I put my note as to who's doing what?
Hi, I'm looking as well to see if I got the second email that you're talking about, because I received two emails twice, one from Miguel and one from Leticia. Both had the Hart versus Odyssey and Etos Holdings.
But
Both
you
of them
didn't get-
had that. I don't see it, but I'm double checking right now. No, I didn't see anything else. 1 second.
Okay, and I didn't receive any of the emails. The only email I got from today was the Zoom link again from Miguel.
Okay.
No.
Anybody got the email with the links? I mean, with
Link?
the case.
Yeah, I
Yeah.
did.
I get Monday at 9. They both
Yeah,
came
yeah.
I got that.
Yeah,
simultaneously.
Yeah, because what happened is it was too large for me to send, and I thought it had gone on Friday. And then when I checked the office on Saturday, they said they didn't receive it. So I said, okay, I'm gonna have to resend it again. So can you send it to?
Okay,
Just
sorry. Mhm.
Yeah, who didn't get it? Say so one person can send it to you.
Does it have five attachments? I see that
Yes,
one now.
yes.
Yes.
Uh-huh.
Okay. Yeah.
And then I send email as to who's presenting what. But if you didn't have a chance to do it, we can leave it for either when you see me again, or if you want to, you can go over them with Miss Dorset.
Okay. No, I don't have that. So if you could just tell me what I'm presenting, and that'd be great. Thank
Yes,
you.
good afternoon. I would need that too, along with the link, what I'm presenting, and the one with the link. I have one email with the two cases.
Now,
only.
not everyone is presenting tonight now.
Oh, okay.
Yeah. I assigned them to certain persons because when I return, those who presented tonight will not be presenting at the next class when I come back.
Understood.
Okay,
you.
gotcha. Makes sense. Thank you.
Yeah. So everybody.
Okay. I didn't get any. I didn't get the presentation either.
What?
No,
There was a
I didn't get that
presentation.
either. Sorry,
No,
you
she
said
mean the cases.
presenters.
She mean the
The
cases.
of the
Yeah.
presenters.
Oh, okay. Okay.
So that's Samantha and who else?
And I got the two cases, Atos
Okay.
and what is this one? An Odyssey. I
No,
got
supposed to be more.
Odyssey, that's it.
No. Okay. Who's going to send them? 'Cause I don't have that.
I don't mind. If you can just both tell me your emails, I can forward them now.
Okay, I'll send my email address to you then. Is that CC?
Do you,
Oh,
you want to just say it, or you want to?
No, I'll send it, so the misspelling, so I'll just send it in the chat if it's not okay. It's okay with you?
I just noticed.
Okay, I'll give you mine. I can give you mine. It's S as in Sam Cartwright at Bahamas Orthodontics with an S.com.
Yeah, they have you on here actually, Samantha.
Yeah.
So yeah, I'll re-forward it. Yeah, I'll send it.
Yeah, the only thing I got was AOTUS and
Okay, so send you the one that has the multiple cases, not the ones we reviewed last week, right?
right.
Right.
Okay, will do.
And then she's saying, sorry, Ms. Archer is saying with the one with the presenters. Was
Yeah,
I
that
on
one, that's in the chain of the email.
Oh,
Once
okay,
you scroll down, you'll see who's assigned to who. That's in the same email. Okay.
okay. Thank you.
You're welcome.
Who else? Henrico
I found my email, sorry.
wasn't junk.
Yeah,
Okay, not a problem.
it's the one with the 6
Yes.
attachments.
Yes. Yes.
I was digging. I found it,
Okay. Well, that's good. You found it.
but
Who was, so I just sent it to Samantha. Did anyone else need it? Or that's it? Who just said they found it?
I did. Henrika found it. Burnt
So
out.
sorry.
Roseanne,
Is it, go ahead. Sorry, I was just asking, is it 5 or 6 attachments?
My
let me
own says
count.
6 attachments.
Okay.
6 attachments.
So if you don't mind, I will give you my email as well, because the one I have has 5 attachments,
You probably missing the largest one.
probably.
No, there's only 5. There's 5
5?
and then there's a separate 2. Is that correct, class?
Yeah, that should be it.
5 and 2, okay. Okay, then I'm okay.
Roseanne, you good?
yes.
All righty, Miss Archer. And Samantha, have you received yours yet from me?
I am still waiting for it to upload. I'm actually on my phone, so I'm still trying to get home.
Oh,
So
so that's a
I'm
lot of
waiting.
data coming through. Yeah, understood.
Yeah, I'm waiting for it to upload on my phone. Okay.
Yeah, it should be coming. Okay. I'm looking at mine now. Okay, so it is 5 cases. One, two, three, four, 5. It's 6.
I have
It
6.
didn't. Yeah. I don't know if it came out because that's what I was saying. But when I sent it originally, it didn't
So-
go. There's supposed to be a case called Patrice Ferguson versus Commonwealth Brewery.
Yeah, I have that.
Okay.
So I don't see the Bahamas Power and Light and Don Smith.
Yeah, I missed.
You know what, Miss Archer, would you mind just going through all the ones we should have? Because I only have 5. I just sent Samantha 5. I got an email with 5
Same.
and then a separate with 2.
Okay.
It is 6 BC. If you look, it doesn't look like the regular attachment. So I just clicked on it and it is there.
Mhm.
Choose
Right.
Ferguson versus Commonwealth Brewery.
Okay.
And then you
But-
have
but-
Kayleen Jervis. Go ahead.
But the Commonwealth Brewery is also in the attachment, in the 5
Correct.
attachments.
It
So
is.
that is there like twice. So
that's there.
that's up there, and then it's also at the very bottom of the email with the little link. So that you get twice, but I don't see one that says Bahamas Power and Light and Don Smith, which has Das Johnson, which is me. So I'm looking for that one,
Oh,
which I don't see.
I
I
may
don't-
have left,
I
I
don't
may
see
have
that
left
either.
that one. Yeah, I may have left that one off because let me tell you the method to my madness. When I go on these sites, I normally print the cases as I come across them, read them, see which area they're relevant to. And then sometimes when I go back, I can't find them. They're gone.
Okay.
Yeah. So I'll have to look on my list, and that may be one that I circle to try and see if I can find it, because normally I write on it. And so then it's difficult for me to scan it to you because I've written up all over the document. But don't worry, you will have the opportunity to present it next class, because we can't do all of these tonight.
Oh, no, no rush.
Okay. All
Just saying.
So that's
And
letting
I'm
you
not sure if I even know what presenting means, but okay, I'm ready.
No, you're just going to summarize what happened.
Okay, that I can do.
Yeah, that's all you're really doing. It's just summarizing. All right, so tonight, we're gonna talk about the employer-employee contract. And normally this area looks more at, in a practical way, we're looking at the breach of contract. When an employee wants to sue the employer because they say that the employer breached some terms of the contract, or the employer says that the employee breached a term of the contract. So there aren't much cases on just pure contract, but it can refer to the employer-employee contract. So this chapter is really about the elements of the contract. And then we're going to look at some cases. So for those, let me ask the question first. Who's familiar with contract law, just the concept of what a contract is in law? Anybody? Don't be shy.
No, no.
Well,
I'm not
I mean, when
familiar.
you're saying,
I'm
and
not
I
familiar.
guess when you added the in-law, that threw me off, but certainly I'm familiar with employee contracts
Okay.
Yeah,
that
I
that
did
we
a-
have
Yeah.
for our associates when they,
Yeah, I'm familiar with employee contracts. Like, I think you kind of threw me off too with when you say in-law. So,
Mhm, mhm.
yeah, I'm familiar
Okay.
with employee contracts, yeah.
I did a business law class and this was like law 101, just a contract.
Okay. Yeah, because we're gonna just do contract law briefly. And then we will look at it in terms of employment contracts. That's the difference.
Mhm.
So I normally start out by talking about what's a contract, what makes a document a contract, and then we apply that to employment law.
Yeah, because reading this, I realized the first part of it talked about contract law 101. And then
Yes.
second part spoke about employee, how it ties in. into
Mhm.
employee,
Right.
contract.
Okay. So if I start with contract law, then we begin with the basics as to what is a contract. And we know a contract is an agreement between two or more parties, and it is enforceable. But before you get to a contract, you have to know what are the elements of a contract. So when someone says, I have a contract, it means that they have had an offer, they have acceptance, they have consideration, intention to create legal relations, they have the capacity to enter into that contract, and there are certainty of terms. So for any contract, those are the essential elements. Now, in addition to those, when you want to question a contract as to whether or not it is valid, then you look at the form, how it was created, whether the contract itself is valid, and you look at the terms in the actual contract. And in the terms, you look at the duties, the responsibility, the obligations, the liabilities, the risk, all of that is included in the terms. Then there's usually a discharge clause, how the contract can be terminated. There are remedies under contract law for when there is a breach of contract, or there is a termination, an early termination of a contract. There are clauses normally in the contract for that purpose. And then there is a limitation. That is the action that could be taken on the contract. And whenever you talk about contract, you'll always hear the term privity of contract. And privity of contract means that if you're not a party to the contract, you cannot enforce it. So an offer has to be different from an invitation to treat in contract law. So when someone invites you to look at a display, that's called an invitation to treat. That is not an offer. Now, in making an offer, it can be revoked at any time. But the revocation has to be made to the person who made the offer or the agent of that person. An offer can lapse after a period of time, or the offer can expire after a reasonable time. And of course, if the offeror or the offeree dies, then before the offer is accepted, the offer terminates. Or the other person is given notice. Now, if an offer is rejected, it cannot be accepted. And that rejection could simply be they decline the offer, or they could make a counteroffer. And an offer that is made to the world at large is one where there's a reward for finding or returning a lost item or a specific act. So acceptance can only take place while the offer is open. And when you accept an offer, it has to be unequivocal. Acceptance can be done by words or it can be done by conduct. And once you accept, you have to communicate that to the person who made the offer to you. So there's no contract if the offeror is not informed or notified that you have accepted the offer. And there are exceptions. And one is when the offerer says that the rule of acceptance, in terms of communicating to me, that is a rule that they're not following, or you're following the postal rule. And the postal rule means that a letter of acceptance that is properly addressed and stamped is effective from the moment it is posted. And that has to be with the caveat that the parties should have agreed that that was the method upon which they were going to use to accept the offer. Now, consideration, remember now for a contract, you need offer, you need acceptance, and you need consideration. Consideration could be money or it can be in kind. So it can be an act that is being done. But consideration does not apply to gifts or to a bargain. Past consideration is not consideration. So you can't refer to something that you've already done to say this is the consideration that you're going to give for a contract. You can't talk about a promise to perform an existing duty. And a third party, again, cannot enforce a contract between two parties or three parties if they're not a party to that contract. You can't have a contract where consideration is based on anything that is not of monetary value. So normally when there is arrangement between family members, brothers and sisters, uncles and nephews, mothers and sons, unless that is something that is drafted formally in a deed, promises or consideration that are based on love or affection are not considered consideration. Now, once you have an offer and you have acceptance, in law, it means that you now have an agreement. So once you have an agreement between both parties, you have consideration. Now, again, in order for that contract to be valid, the parties must have the intention to create legal relations. That means that they must be of the age of majority and of the right mind and not bankrupt in order to create legal relations. And again, social and domestic arrangements are not a part of the intention to create legal relations because they're familiar. Bear in mind, a contract can be an oral one, or it can be in writing. So once the persons have the intention, which refers to their mind, add to that is their capacity. And the capacity means whether or not, if it's an individual, if they are of sound mind and they are not bankrupt. And it depends upon the purpose for executing the contract. Then there are other elements to look at in terms of being of sound mind. Be mindful, if it is a company, the persons who act on behalf of the company must have the authority to do so. And the same as if it is an individual, that individual must have the authority to act on behalf of the party to the contract. So a contract can be valid, it can be voidable, or it can be void. So once you've entered into a contract, there are ways in which you can discharge that contract. The parties can just agree that they are finished with the contract, or they can carry out their obligations as stated in the contract, or there can be a breach. And you'll see that a lot in the tribunal and the Supreme Court cases where there are breaches of contract. And the contract itself can be frustrated. And frustrated means that there is an event outside the control of either the employee or the employer, which makes it incapable for either party to discharge their obligation or duties. So the remedy for the breach of contract can be damages under common law. It could be an action for an agreed sum, or it could be quantum merit, as much as it's worth. And you'll see this as we go through the tribunal cases where the president or the vice president comes up with how much either the employer has to pay or the employee has lost. Under equity, you can ask the court for specific performance, which means I want my job back. Or you can ask for an injunction to stop an action. You can ask for a rescission, which means that the court will terminate the contract. Or you can ask for rectification, which means there's been a mistake in the document. But always remember that equitable remedies are discretionary. Now, if you take that principle of contract law, meaning you must have offer, acceptance, consideration, intention to create legal relations, you must have the capacity, then you need to apply that to employment law. Because employment law is a subset of contract law. Because you're going to see the same elements from enacting just a contract in drafting an employer-employee contract. First, there has to be an offer. There has to be acceptance. Consideration will be the salary that is being proposed. Then you have to look at whether or not the parties intended to create that legal relation, which means that the employer was serious about inviting you to make a decision whether or not you will accept an offer or not. And the employee will then demonstrate by saying, yes, I accept this offer and I accept the salary and the terms and condition that you are proposing. Then they have to be of legal age, unless they are an apprentice. And then comes the certainty of terms. So a contract, a formal contract between the employer and employee is a binding one. It stipulates the rights, the responsibilities, duties, and obligation of both parties. It could be oral, or it can be in writing, or it could be both. Typically, it's in writing, and they do that to avoid any conflicts, any ambiguity, making sure that the rights and the duties, responsibilities are all laid out in the actual written contract. So where a contract is made orally, it is always recommended that the employee obtain a written statement of the essential terms and conditions within 2 months of the commencement of employment. And all parties to a contract of employment are bound by the terms and condition. And unless it is terminated by notice, variation, or breach of contract. And we do have some cases that went to the tribunal referring to their contracts being varied without unilaterally. So there are only two parties to the employer-employee contract. That's the employer and employee. Any other person does not have privity of contract. Only the employer or employee can sue or seek a relevant remedy for breach or termination of their contract. Now, when you talk about the employee-employer relationship, you also have to determine who is an employer and who is an employee. And that needs to be done because you have to look at when you're enforcing your rights, your duties and responsibilities and assigning those to parties, you have to look at what is the liability to either side. So equity says that they look at substance and not form to determine whether a person is an employee or they are an independent contractor. It doesn't matter what you call the person. The court looks at substance. So they look at the nature of the relationship, the content of the relationship between the employer and employee. And then they look at the duties and the responsibilities, not necessarily as to what the contract states or describes that individual as. So whether a person is an employee or an independent contractor depends on whether that person is under a contract of service, which is normally for an employee, or whether they are performing a contract for service. A contract for service is an independent contractor. So in addition to those things, there are other things that the tribunal will look at. One is whether the individual owns or is performing work for his own business or that of the employer. Whether the employer has a certain degree of control over the individual who's doing the work. Whether there is a pecuniary interest or economic gain from that person performing the work. Whether that person is a part of the employer's business or their organization. And that's why you see sometimes you have to be very careful when you ask employees to conduct work or for the organization that is not a part of their duties and responsibilities. Because then are they acting or it doesn't fall under any other duties as assigned. is whether the employer provides the tools of trade and equipment to carry out the work. And then to who has the responsibility for paying that person's national insurance. Whether or not the parties had an intention to engage in an employer-employee relationship. You have to look at the understanding and the perception as to the type of relationship that was intended or what exists between the two parties. Whether or not the profession or trade is one that's designed for a particular relationship. Or the ability of the employer to hire and appoint an individual performing the work. You look at the duty and obligation to work by individual, and you look at the payment of salary and wages, and whether or not the person who's performing the work will be assessed by the employer, and whether the employer can unilaterally determine the time and place of work. And of course, is whether or not the employer can do any acts of discipline, suspend or terminate the individual. So when you look at the offer of employment, you have to make it clear, and it has to be unequivocal, and it has to demonstrate the intention of the employer to be bound by the contract. But it must also be communicated to the individual to whom it is being made by the employer. There shouldn't be no ambiguity and no confusion. Background checks, needs to be done. And you have to make sure that the contract of employment itself is drafted and it is legal. Any preconditions should be set out in the contract. Now, an employee can accept it expressly or impliedly. And an offer of employment may be expressly accepted by the employee orally, communicating it to the employer, or formally by signing the contract. It may be implied or indirectly accepted by the person either coming straight on the job to do the work or just arriving to work. That can also mean acceptance. So following the general principles of contract law regarding acceptance, the acceptance of an offer of employment may only take place while the offer is still open. And again, acceptance must be unequivocal. In other words, it must be absolute, unqualified, and clear in its expression. And acceptance cannot be considered a counteroffer. A lack of agreement between the parties on a particular term of the employment contract does not invalidate a contract of employment. Unconditional job offer that is being made by an employer and accepted by the employee creates a binding contract of employment. For consideration, often the employee's performance of the assigned duties under the terms and condition of the contract and the employer's salary payment to the employee for work done under such terms and condition is equivalent to consideration. And of course, intention to create legal relations is the binding of the minds of the two parties, and it can't be on a social or a humorous context, because it is a serious matter entering into a binding contract. For capacity, besides being of legal age and not being mentally challenged, you cannot be a bankrupt, because a bankrupt person cannot enter into a legally binding contract. The employer's capacity is the same as under contract law. The person who is negotiating the contract and signing on behalf of the employer must have the authority to do so. And an employee's capacity to enter into and enforce a contract of employment is important to ensure that their rights are recognized and protected by the employer. Now, the terms of the employment contract has to have certainty. There can't be any ambiguity, because then it leads to legal liability. So the terms of the contract of employment must be drafted and represented with clarity and certainty as to the nature, the ambit, and the scope of employment. Within every contract of employment, there are standard terms and conditions, and these can be expressed or implied. Expressed terms outline the nature and the ambit of the work to be performed, the duties and obligations of the employee, and the rights and responsibility of the parties. So normally a standard contract of employment includes the name of the employer and employee, their job title, a brief job description, the date of commencement, the duration of the employment, the salary or whatever pay arrangements, the duties and responsibility of both the employer and employee, the hours of work, the benefits, vacation, national insurance contribution, sick pay arrangements, pension scheme notices, disciplinary and grievance policies, collective bargaining, termination. Now, sometimes some of these things are contained within the employee handbook. So under the Employment Act, Section 5, it sets out what should be in the employment contract. So sometimes you will see the contract between the employer and employee is sometimes referred to as the contractual or statutory statement. That's what they'll call the contract of employment. And it's called a statutory statement because the provisions of the contract are set out under the Employment Act. So the Act Section 5 says that the contract should have the name of the employer, the undertaking and of the place of employment, the name of the employee, the place of engagement, where practicable, the place of origin of the employee, and any other details for employment, the nature of the employment, if the person is engaged for a fixed period or in appropriate circumstances, the duration of the employment, and the method of calculating the duration, the rate of wages and other benefits, the manner and period of payment of wages and other benefits, the advances of wages and other benefits, and where any work is to be performed, not by the piece, but by time, the number of hours of daily work, and the hours of the day at which such work is to commence and to terminate. And these terms are included in a written contract of employment in order to ensure compliance with the law and to safeguard against unintended discrepancies in the terms and condition that is being mutually agreed by the parties. Other terms may be incorporated into the contract of employment through custom and practice. And some contracts have restrictive covenants, and they restrict the action of the employee either during the time of his employment or for a specified period after the employee has left the employer's place of work. The employers also have an obligation and an implied duty to notify their employees of employment rights that they would not ordinarily be aware of. But if an employee knows about such employment rights or ought to have known of them, then the employer's omission or inadvertence is of not informing the employee about such rights will not amount to a breach of contract. So in employment law, the contract is not signed by any one or more of the parties, is still valid and enforceable, particularly if the parties have carried out or adhered to the terms and condition within the contract by their conduct. Now, there are different types of employment contracts. You have the permanent employment contract, And that incorporates both the statutory and the common law contractual terms in the agreement. You have the temporary and fixed term employment contracts and an agreement between the employer and a temporary worker is often hired on a fixed term basis and ends on a certain trigger, which are drafted into the contract. Temporary fixed term employees should not be offered new contracts of employment on terms that are less favorable than those of his original employment contract. Similarly, under the contract law of contract, an original contract of employment will end if the employer intends to change and actually changes the terms of the contract without the consent or assignment of the agreement of the temporary or fixed term employee. And in that case, the temporary fixed term employee has grounds to make a claim for unfair dismissal against the employer. Now, you can also have contracts of apprenticeship, and that's an agreement between an employer and the apprentice, and the apprentice agrees to work and be trained by the employer for specified time, pay, and under certain conditions. An apprenticeship agreement is normally drafted and entered into by the relevant parties for the purpose of training and terminates when the training is complete. An employer may include early termination provisions subject to common law principles governing such contracts. And employers who engage apprentices or trainees under contracts of apprenticeship are not required or bound by law to offer employment to those apprentices or trainees at the end of the apprenticeship period. So even if the relevant elements of a valid contract are existent, it should be noted that if there are terms of the contract that are considered illegal under law, the contract is considered an illegal employment contract, and the rights and duties and obligations that comprise the terms of the contract or are referenced by the contract cannot be enforced by either party. A contract of employment may not be considered illegal if it is entered into between the parties in good faith. So when the court looks at an employment contract as to whether it is illegal, the test was settled in the case of Enfield Technical Services versus Payne, where the EAT in an earlier ruling stated that illegality is to be determined where the parties have knowingly entered into arrangements which have, to their knowledge, represented the facts of the employment relationship to be other than they really were. So whether the individual does not have the legal capacity to enter into or enforce the contract, the terms of the contract are illegal. And some illegal act make the contract void or voidable. And the existence of the essential elements for a valid contract does not automatically make a contract legally binding. So generally, the terms of the contract of employment may be varied by a mutual agreement of both parties, or it can be unilaterally by either party, and it depends on the circumstances. So where either the employer or the employee seeks to vary the terms of employment, either unilaterally or mutually, within the duration of the contract, the variation must be done with the express or implied consent of the other party. In the Bahamas, it is established law that no employer has the right to vary a contract of employment without the express or implied consent of the employee, unless the employee has given the employer the power of variation through contract or agreement. So where an employer varies a contract of employment unilaterally and notifies the employee of his variation, the employee doesn't agree with the change or alteration to the contract, it is advised that the employee should make his disagreement known to his employer, preferably in writing, as soon as possible, notwithstanding the fact that he must still continue to work as agreed under the terms and condition of the employment contract. If the employer continues to carry out the variation exercise, the employee has a legal right to report and file a trade dispute with the Ministry of Labor or bring a claim or action against the employer in the Supreme Court for breach of contract. And just as under contract law, under employment law, an employment contract can be frustrated. And that's where the parties to the contract cannot repudiate the contract by intentionally or willfully frustrating it. The burden of proof is on the party who alleges that the contract has been frustrated. So the frustration of a contract of employment occurs where there is an unforeseen, uncontrollable, or intervening event that the parties experience, and it affects the terms, conditions, and execution of the contract. An event that is foreseen and stipulated in the contract of employment cannot be frustrated under the law of contract. So remember that whenever a contract is frustrated, it has to be something that is unforeseen, uncontrollable, or is an intervening event out of the control of that person. Any comments?
No, not here.
I have a question.
It's a lot.
I was thinking frustration was more like when somebody intentionally was trying to get out of their contract. So
No.
my thought was totally different.
No, you're taking the
Yeah.
literal definition of
Yeah,
no, not under contract law.
okay.
I could give you an example where it could stick in your head. So let's just say you were building, you had a contract to construct a building in Abaco,
Mhm,
and Hurricane Dorian came.
mhm,
It would not have been foreseen that it would have been a Category 5 hurricane.
mhm.
So if you look at your contract, you probably were supposed to have been finished in 3 months, 4 months.
Mhm.
According to Hurricane Dorian, nothing can get done. So
Yeah,
you can complete your contract. So that is uncontrollable.
okay. That makes sense.
Okay, I have a question about the variation of the employment contract. For example, if an employee was hired as a housekeeper and then she got transferred to as an office assistant. I mean, this is actually a real case. No salary change, but her position changed, and so of course her responsibility changed. Is that a variation? And we would have you. It's best to document that, correct?
Yes, yes.
That's like one of the cases. It wasn't mine assigned, but I think you assigned us one that's similar to that.
Oh, okay. So let's start with you then.
No, I said it wasn't mine. I don't know who was assigned the case. I can give you the name of the case, but I was reading through it. I have another one. I'm Brandley and Perfect Luck.
Yeah, I wanted to start with Joycelyn Curry.
Who had that one?
Who was that one? Bastian, Roseanne.
Okay, I'm just saying these cases today, so
Okay, you want us to skip you?
yes, please, until
So
next time.
when I return, we will start with you.
No problem.
Okay, so I'm gonna put a little X here by your name for next time. And I'll be sending some other cases for when I return,
Okay,
okay? What's the next one? Since what is lady name? Since City Hall?
Yes, in City Hall versus Lockhart, Chilcott, and Chancellor. I have this page. There's 2 pages, right?
Yeah.
Yeah, okay.
Well, more than 2.
Okay. Well, it was based on the orders on direction between City Hall, Lockhart, Chilcott, and Chancellor. So I'm assuming this would have been connected to Chapter 2, where we discussed the tribunal procedures and the rules of the
Yes.
tribunal. Yeah. Okay,
Yeah.
good. So it took us through, you want me to read the case or you just want me to analyze it?
You could just analyze it.
Okay,
Everybody has to read it, so.
okay. Okay, so it starts off where a certificate of referral was dated October 11th, and the minister referred the subject to dispute to the industrial tribunal. And it goes on to talk about how the tribunal would have issued a request for the originating application. That would be Form 8. The tribunal secretary would send this to the applicant, which in this case would have been Sun City Hall. So Sun City would have gotten that request November 5th, 2018. And so when she got the request, she had 14 days to file the originating application based on the rules of the tribunal. So she had to put in her details, her name and her address within a 14-day window. So Sun City eventually filed that to the tribunal on November 12th, 2018. So then a notice of application to the respondent, in this case, Lockhart, Chilcott, and Chancellors, of Form C was sent, and it also had a notice of appearance, which is Form D. They were sent to the respondent November 15th, 2018. So after November 15th, Lockhart, Chilcott, and Chancellors had 7 days to respond to this notice to the tribunal. So based on the timeline, Lockhart, Chilcott, Chancellors did not respond within the 7 days. And they filed their Form D, the notice of appearance, on December 3rd, 2018. And they filed their defense, which I guess the defense against the applicant on January 17, 2019, the following year. So what I took from this was that the respondent delayed the process or the time frame that they had to respond to the tribunal notices. And so the tribunal had to send it to a case management hearing. And Ms. Archie who confirmed if that's what happened, where the tribunal had to, I guess, send this to case management to kind of direct the next step, since it didn't follow the tribunal rules.
Mm-hmm.
Okay, so that they assigned this and set a date for February 18, 2019. For the, they adjourned, or they had several adjournments, what happened, and the parties were given April 23rd, 2019 to complete the case management hearing. And that's what I took from that. The respondent didn't follow the protocol of the tribunal and the rules. Okay.
Mm-hmm.
Okay.
And that's how important. Remember when we did the unit on the tribunal? That's why I went through each one of the forms.
Mm-hmm.
It's important that you follow the process. If you don't follow the process, this is what happens.
Mm-hmm.
And over the weekend, I was trying to find some other cases that we could look at in our other 2 classes when I come back. And there were just so many cases that were just thrown out.
Wow.
Yeah, the processes were not followed.
So question, does this go against the respondent in this situation? That they were delayed in filing their case?
Yeah.
Okay. Okay.
Mm-hmm.
Okay. Okay. Yeah, that was a short one.
All right, Brandley.
Okay, that's me.
Okay.
So this is Brandley Mortimer Roberts against Perfect Luck Employer, which I thought was actually one of the number houses, but I realized that it wasn't. It's Malia. This was a civil appeal for unfair dismissal, breach of contract, pleadings, and suspension without pay. So the appellant was terminated from her employment with Respondent Company in January of 2017. And following her termination, she brought an action against the respondent on the basis of unfair dismissal and a breach of contract. So this person was a front desk supervisor, and she, alleged that she was also part of the group medical, so fully in a contract with this employer, and also claims to be a member of the Bahamas Hotel Managerial Association, which is a registered trade union. She indicated that she supervised about 15 persons. And on January the 8th of 2017, she was working a midnight shift and was informed by a coworker that there was a request from Air Canada who had a distress flight. So in summary, what happens with these distress flights is depending on who registers them, they get what they call an upsell. She, being a supervisor, would not be entitled to that upsell. So she informed one of her direct reports, and the direct report asked if she could get her upsell because she knew she would be able to receive that. She told her that in order for her to receive it, she would have to sign into her terminal. And she did so. She alleged that she did not know that would create a problem because she was unaware that she couldn't give her upsell to another person if that person was on duty. As a result of this action, she was suspended without pay for 5 days in breach of the relevant provisions of the industrial agreement. The defendant terminated her contract without reference to the relevant provisions of the industrial agreement, thereby breaching her contract of employment. So that's what she's alleging.
Mm-hmm.
Is everyone following me so far? She said also that she was never reprimanded. She was trying to allege, you know what, I've had a pretty solid record up until now, right? And that before she was terminated, she worked for public holidays and they did not compensate her for one of them, the majority rule day. Okay. So the defendant is alleging that the plaintiff continued to be employed until January the 12th, when the defendant unfairly terminated the plaintiff's contract of employment. Her right not to be unfairly terminated is provided by Section 34 of the Employment Act 2001, and failed to give the plaintiff notice of termination or payment in lieu of notice. This is a long one, so I'm trying to summarize here. Let me know, Ms. Arch, if I'm missing any major points.
Okay, go ahead.
Okay. So I will say this, I was a little bit confused about this final ruling, right? It was stating that she really was not, if I'm correct, Ms. Archer, that she really was not a part of this trade union. Is that correct? Because didn't it, so this group of companies, the trade union was no longer at that time under the company she was actually employed with, or did I misread that?
No, you're right. See, that's the funny thing when we do trade unions. I have few cases on local trade unions, and you will see how, like when they're in the process of negotiating, that's tricky. That's the tricky part. Yeah, it's a tricky part.
Yeah. This other tricky part is when it begins to, and this is where I'll need your help when we get to page 7 and 8, when they begin to reference other cases. I guess they're trying to say, this is aligned with some prior presidents, correct?
Yes. So, remember that would have been chapter 1. Remember when I said that when you take a matter to the court looks at what's the issue at hand in law. So in this one that you're doing now, Brandley, the issue is she's come saying that she was suspended without pay.
Right.
And according to her, you breached her contract. Right? And she says, and my breach of contract was unfair. I was unfairly dismissed. So really,
so this is a great question. So suspension with or without pay, is that based on the employer and what their policies state? Because I've known, and I will apologize, I am new to corporate Bahamas. I was primarily US domestic, and it was pretty clear that if an investigation was pending and we wanted to suspend someone, they were paid for the time we were investigating. It seems like that's not the case here. Is that correct?
I guess it depends on the employer.
That's what I said. Does it depend on the employer? Okay, yeah, US domestic, we don't the employer is not penalized because it may take an employer, 30 days to investigate or what have you. They're paid during our investigation time. That's what I was wondering. It's dependent on the employer here locally.
Yeah, it's based on case law. So you go, when you go to the section on page 9, suspension without pay, then you'll see how the court arrives at whether or not suspension should be with pay or without pay, because it's not in the Employment Act.
The court decides, so not the employer. Okay.
Yeah, so you'll
Okay.
get that when you get to page 7, you're there now though.
And that's where I'm saying this is where I'm getting lost. That's why I need your
Okay.
help. Yes. Mhm.
All right. So let me go from. So the plaintiff is saying that the terms and condition of our employment is embodied in that industrial agreement between
Right.
between Perfect Luck employer and the union. So she's saying that because she was unfairly dismissed and the breach of her contract, she's saying that she suffered loss and damages. So she set out her particular damages, her basic award, according to the Employment Act, her compensatory award, her vacation pay, whatever's her meal allowance, suspension pay for 5 days, and then her group medical insurance to be assessed. So she's come to the amount of
56.6. Mhm.
5660.
Mhm.
So, and then she says any other
Plus
relief,
interest.
right? Because remember now, for breach of contract, she can go under common law or she could go under equity. The court uses its discretion if the court thinks that you should be awarded more.
Mhm.
So the court says in dismissing Brandley's action, the learned judge at the lower court made these observations. He said in this matter, the plaintiff is claiming unfair dismissal. The statement of claim, however, in my view, fails to meet the threshold in the case of Eden Butler versus Island Hotel Company Limited. That's a Bahamian case. He said in that case, it was quoted by the judge, as is evident from the amended statement of claim, the appellant provided no particulars of his claim for unfair dismissal. A plaintiff must complete a statement of claim in which are set out the allegations of facts they intend to prove. In the aggregate, those allegations of fact, if proven at trial, must suffice to give rise in law to the relief being claimed. The plaintiff would have to provide sufficient detail in the claim so that the defendant knows what the allegation of facts are. Otherwise, that person cannot defend. So you can see you're already getting to the point where the judge now in the Court of Appeal is saying, you're coming to make a claim, but you have not set out your case.
Yeah, that's where I was getting confused. So you're saying she's just saying very generically, I was unfairly dismissed, but not giving the specifics thereof. Is
Yeah.
that what this is saying? Okay, okay, just making a statement without any facts to back it up,
Yeah.
basically. Okay.
So then the judge in the Court of Appeal says, in the case of Al Madini versus Mars UK Limited, the judge giving the decision of the English court said, it is fundamental to any adversarial system of justices that the party should clearly identify the issues that arise in the litigation so that each has the opportunity of responding to the points made by each other. The function of the judge is to adjudicate on those issues alone. The parties may have their own reasons for limiting the issues or presenting them in a certain way. The judge can invite and even encourage the parties to recast or modify the issues. But if they refuse to do so, the judge must respect that decision. One consequence of this may be the judge is compelled to reject a claim on the basis on which it is advanced, although he or she is of the opinion that it would have succeeded if it had been advanced on a different basis. Such an outcome may be unattractive, but any other approach leads to uncertainty and potentially real unfairness. So the starting point must always be the pleadings. So here the judge is saying that you come now to the Court of Appeal to appeal the decision that was made in the lower court, because the decision in the lower court would have been in favor of Perfect Luck.
The Perfect Luck, yeah, it was,
Right.
yeah, that's why she's appealing, yeah.
Mhm.
So it's
And-
basically saying you're coming to this higher court, but you haven't presented any additional evidence to support?
Yes. And
Okay.
what is the real issue? So he says further down, where one party advances a case that is inconsistent with his pleadings, it often happens that the other party takes no point on this. Where the departure from the pleadings causes no prejudice, or where some other reason it is obvious that the court, if asked, will give permission to amend the pleading, the other party may be sensible to take no pleading point. Where, however, departure from a pleading will cause prejudice, it is in the interest of justice that the other party should be entitled to insist that this is not permitted unless the pleading is appropriately amended. And that then introduces, in its proper context, the issue of whether or not the party in question should be permitted to advance a case which has not hitherto been pleaded. So you've already seen where he's come before the Court of Appeal and he hasn't stated what his issue is.
Mhm, mhm.
So he say before us, Mr. Ferguson raised two main issues. And Mr. Ferguson is the attorney for Brandley Mortimer Roberts. So firstly, that the respondent suspended the appellant without pay. That's what he's saying, that Brandley attorney is saying, which he says was a fundamental breach of the contract of employment. And secondly, that the appellant was unfairly dismissed, as there was a failure to afford to the appellant the right of a fair hearing to which she was entitled. So the judge said, let's look at suspension without pay.
Yeah, that's the one that was confusing, yes.
Right. So he says, it should be noted that the only reference to suspension in the statement of claim was in paragraph 7. And it said, the defendant suspended the plaintiff without pay for 5 days, contrary to the plaintiff's contract of employment.
Yeah, let's
It-
get to that. Okay, so that contract of employment was not via the industrial agreement? I mean, the trade union?
We got to read further to see that first.
Oh, okay, I
Because-
thought you were familiar with the
yeah.
case. Okay, I got you. Okay.
It is to be further noted that there is nothing in the pleadings which asserts that the alleged breach was a fundamental breach, which went to the root of the contract of employment. When pressed by this court to provide authority for this submission, Mr. Ferguson relied on the case of Carlton, Butler, and Paradise Island, where the judge at that time, he relied on the ruling of the case of Hanley and Pease, where it was stated that in the absence of an express power giving entitlement to do so, the employer acts in breach of contract by suspending the employee from work without pay. So here
So when I read that, it sounds like they are in breach. That's what confused me. In the absence of an express power giving entitlement to do so, the employer acts in breach of a contract by and that's what they suspended this person without pay. So I'm not sure why
Okay.
they're. Okay,
Hold on.
all right, I'll hold on.
All right. So that it is to be noted, however, that a close reading of the decision in the Carlton Butler's case shows that the learned president in that case did not find that it was a fundamental breach.
I read that as well, but let's keep going. Let's keep
Okay.
going.
But even more significantly in that case, the learned president observed as follows. Before I proceed to go into the merit of the applicant's claim, perhaps I should state the legal position as I understand it with respect to suspension without pay. The case that is cited as the authority on this point is the case of Hindley and Pease. This case established that in the absence of an express power giving entitlement to do so, the employer acts in breach of contract by suspending the employee from work without pay. Whilst the contract continues, the employee can sue for damages representing lost wages during the period of unpaid suspension.
Right? It still sounds like it's on our side right now.
Okay.
Let's
In
keep going.
Okay, in Carlton Butler's case, the learned president, while finding that there was no power to suspend without pay, resolved the matter by ordering that the employer pay to the employee 10 days' salary for the relevant period of suspension of $53.40 from the date of suspension. Now, Mr. Ferguson was able to provide us with no authority which supported his submission that suspension without pay, in the absence of express power to do so, constituted a fundamental breach which brought the contract to an end. So the lawyer did not bring in his pleadings any case to support what he was saying, that being suspended without pay is a fundamental breach of a contract. That's what paragraph is saying.
I see it, but everything before says it was.
But he has to plead it. You
Oh,
can't
just
just,
because. Oh,
you
I'm sorry,
can't
go.
come to the court and say it's a fundamental breach.
Mhm.
You have to support it with case law.
That's not what 11, that's not what 10 and 11 were doing? Were
10
those
and
not
11,
case?
but it was not done by him.
Oh, okay.
This is
So
the
it's
judge.
put before the judge, but because he didn't say it, it doesn't apply?
You're gonna go on this
Okay.
way.
All righty. Well, I was trying to, I felt so bad you're reading this. I feel like I should be reading it. Sorry,
No,
Ms. Archer.
Class.
You assigned it to me. Sorry.
You'll be there, don't worry. So Mrs. Major submits that there is no such evidence that the appellant's suspension without pay amounted to a repudiation of the contract of employment. She noted that at the end of the appellant's period of suspension, she returned to the workplace for the return from suspension meeting and continued to participate in the disciplinary proceedings. Now you see what she did? She returned to work. So if she returned to work, how can you now say that the suspension without pay was a fundamental breach? A fundamental breach means that the contract cannot be performed. So in addition, Mrs. Major submits that the appellant is bound by her pleadings, and she further submits that the appellant did not plead that her suspension without pay amounted to a repudiation of the contract of employment. Counsel concluded that in any event, it is not for the court to speculate regarding the details of the alleged breach, and that in the absence of any particulars, the appellant's claim for breach of contract was bound to fail. Because if she returned to the workplace after the suspension, she
Right.
continued to participate in the disciplinary proceedings, then how
Okay.
can you say that suspension without pay was a fundamental breach? And remember, fundamental breach means that the contract has come to an end. So if it came to an end, why were you returning?
Well, then if it came to an end, that's not even a suspension. She was not even contractually employed. They're two different things, in my opinion. Suspension means you're still an employee of the employer. They're just suspending you from working.
I agree with you.
So that's not so then those are two different things, in my opinion. That's why I'm getting lost here.
Okay,
Right.
what her lawyer is saying is that because she was suspended without pay, he's saying that that was a fundamental breach. It brought the contract to an end. That's what he's arguing. And the court,
The light bulb
Okay.
goes off. Okay,
Right.
I gotcha.
you got
So
it?
he's saying
Right.
the contract ended because I'm with you, but it
Okay.
could not have ended if she returned. I'm with you. Okay,
Yeah.
okay, I'm with you now.
Okay, all right.
Okay. You
So
missed that
fine.
part. So now I got
Okay.
it. Okay.
So finally, on this issue, Mrs. Major contends that as a part of the respondent's defense, it was pleaded and argued in the court below that certain terms and conditions of the expired industrial agreement had been incorporated into the appellant's individual contract of employment. So remember, when we talk about employment contract just now, and I said that sometimes in some instances where you have an industrial agreement, parts of it are incorporated in the contract. This, she said, was pleaded in paragraph 10 of the defense, and the evidence in support of this line of argument is contained in paragraphs 15 to 16 of the witness statement of McKinsey, as well as in her viva voce evidence, which means when she came to court, she gave evidence about it. Counsel concluded that in essence, the evidence of McKinsey was that after the expiry of the last formal industrial agreement, certain terms of the agreement continued to be followed as the terms of contract for individual employees. Such terms included the disciplinary provisions regarding the breakdown of minor and major breaches and the utilization of suspension without pay as a tool of discipline. So you hear what she's saying now about the agreement. In the industrial agreement, there were certain terms, one of them being a disciplinary provision. And one of the disciplinary provision was that you can have a suspension without pay.
Yeah.
However, it was also her evidence that the provisions of the industrial agreement, which related to the union itself, did not continue as part of the individual contracts of employment. So now her next thing was that she was unfairly dismissed. That was her second ground.
Right.
So she said she was unfairly dismissed as there was a failure to afford her the right of a fair hearing to which she was entitled. So in her statement of claim, she stated that the plaintiff continued to be employed by the defendant until January 12, 2017, when the defendant unfairly terminated her contract of employment and her right not to be unfairly terminated as provided under Section 34 of the Employment Act. And she said they failed to give notice of termination or payment in lieu of notice. As a result of the defendant's unfair dismissal and breach of the employee's contract of employment, she says she suffered loss and damages. So it says in paragraph 17, it's obvious that no particulars of the alleged unfair dismissal have been pleading. And they said that it is surprising, having regard to the 10 of the terms of the Employment Act governing unfair dismissal. It is to be noted also that the statement of claim does not specifically lay out a claim for wrongful dismissal. It is therefore interesting that the relief which the appellant now seeks from this court is an order that the learned judge's decision from the lower court be set aside and the action be restored and be converted to an unfair and wrongful dismissal claim pursuant to the plaintiff's pleadings. In disposing of the unfair dismissal claim, the learned judge relied primarily on the lack of proper pleadings. His comments are set out above, but I repeat them here for proper context. He said, in the instant matter, the plaintiff is claiming unfair dismissal, and he filed a specially endorsed writ of summons in 2018. The statement of claim, however, in my view, fails to meet the threshold that was settled in the case of Eden Butler versus Island Hotel Company. Again, he's quoting the same thing that we had read earlier. That is evident from the amended statement of claim. The appellant provided no particulars of his claim for unfair dismissal. A plaintiff must complete a statement of claim in which are set out the allegations of facts they intend to prove. In the aggregate, those allegations of fact, if proven at trial, must suffice to give rise in law to the relief being claimed. the plaintiff would have to provide sufficient detail in the claim so that the defendant knows what the allegation of facts are. Otherwise, that person cannot defend. The nature and extent of particulars depend on the nature of the claim. If, for example, trespass is alleged in the claim, the allegation of fact must make the claim out. Similarly, for breach of contract, the claim will set out the material terms of the contract and the details of the alleged breach. In my opinion, the statement of claim in the instant matter has not risen to the required standard. And in light of the evidence, therefore, and in all of the circumstances, the plaintiff's specially endorsed writ of summons is hereby dismissed with cost to the defendant to be taxed if not agreed. So in his submissions before us, Mr. Ferguson sought to argue several issues relative to the application of the expired industrial agreement between the Bahamas Hotel Managerial Association and the respondent, and the extent to which those terms were incorporated into the employment contract of Brandley. He further sought to persuade us that the disciplinary process was not properly carried out. However, it is difficult to see how we can fault the learned judge on those issues were not properly pleaded. And although some submissions were made before him on these points, no amendments were made to the pleadings. So you see what's happening here, right?
I do. I do.
These assertions are being made, but the pleadings were not made to flesh out all of
Yeah.
these. Yeah.
Exactly. So they're not blaming the initial learner judge. They're saying, we're not blaming him because it wasn't properly laid out.
Yes, yes.
Mhm.
So then he went to wrongful dismissal.
Mhm.
Again, I would note here that notwithstanding the failure to properly plead a case of unfair dismissal and not having specifically put a case of wrongful dismissal, the learned judge took the precaution of dealing with those claims. The learned judge's findings relative to the unpleaded or not properly pleaded wrongful dismissal claim were as follows. The investigation. Based on the investigation, it would appear that a thorough investigation was carried out in this matter. There was information as to how the upsell was processed. This was not only ascertained from the plaintiff in the interview, but also from the internal investigation by the defendant. The plaintiff was only terminated after the return from suspension interview. She had an opportunity to explain her actions and did so. And if I may say, honestly. However, it is obvious that the defendant considered what was done to be a major breach of contract. The events which led to the plaintiff's termination resulted in another employee being put in a position to benefit when she was not entitled to. In fact, that employee was not even scheduled to be at work when she was allowed by the plaintiff to access the defendant's computer system to upgrade a transaction referred to as an upsell. The plaintiff admitted that she committed a wrong. Breach of the obligation of mutual trust and confidence. You'll hear about that in the next class. The evidence shows that the plaintiff was only terminated after a thorough investigation and after the plaintiff had an opportunity to address the allegations made against her by the defendant. So a review of the statement of claim shows that the specific breaches alleged by the appellant were as follows: that the plaintiff continued to be employed by the defendant until January the 12th, when the defendant unfairly terminated the plaintiff's contract of employment, her right not to be unfairly terminated as provided by Section 34 of the EA, and failed to give the plaintiff notice of termination or payment in lieu of notice. That the defendant breached paragraph 4 of the progressive discipline documentation, that the defendant suspended the plaintiff without pay for 5 days, contrary to her contract of employment. And at termination, the defendant paid the plaintiff in respect of 3 public holidays, worked during Christmas Day, Boxing Day, and New Year's Day, but failed to pay her in respect of Majority Rule Day when she worked. So the judge said the allegation in paragraph 3 was the overarching position of the appellant's claim in the court below. Paragraph 4 is unclear, as there are no adequate pleadings to establish the issue being raised. The purpose of progressive discipline is to give employees the opportunity to improve their performance or change their behavior before severe disciplinary action is taken. In essence, it's really a way of saying that the decision to terminate was too harsh. Not only did Mr. Ferguson not provide particulars, but also he did not develop the point in the court below, nor did he develop the point before us. So you see the trend that's happening in this matter, right? What's the trend?
Not proving their case. I mean, not being able to prove. I think. Did someone else want to add something?
Oh, sorry, I said exactly, sorry.
Oh, you
My
said
mic's
exactly.
open, I just realized.
Oh, that's okay. Go ahead. Go ahead. See, at paragraph 23, the judge says the big point raised by Mr. Ferguson at trial, but which was not pleaded, was that the appellant was not allowed to have union representation at a disciplinary hearing. However, the learned judge found not all of the terms and conditions of the agreement carried over into the individual contracts of employment, and that in particular, clauses or parts of clauses regarding the union did not carry over into individual contracts. I should note also that as submitted by Mrs. Major, no evidence was led that the appellant sought union assistance and that assistance was blocked by the respondent. There is therefore no merit in the appellant's claim for unfair or wrongful dismissal. Now, how
Oh,
could
that's
you
interesting.
go-
So she didn't even go to the union, but yet
No,
she's claiming that she should fall under their agreement.
No, she did not.
Mm-hmm. Mm-hmm.
Did not. And that should
Right.
have and that should have been one of the fundamental questions he should have asked and taken this matter before the court.
Exactly. Yep.
So, resolution. The judge says, I'm satisfied that the appellant's case, as pleaded in the statement of claim, was bound to fail. In the absence of specific pleadings and particulars of the items pleaded was fatal to the claim. In my view, the learned judge would have been on good footing to dismiss the action on that basis alone. However, in fairness to the appellant, the learned judge did in fact consider the submissions made by counsel, which were not properly covered by pleadings. I can find no fault with his determination on those issues. I have also given consideration as to whether the penalty imposed on the appellant was too harsh. In this regard, it should be noted that in her written statement, recorded by Security Officer McQueen and referred to by McKinsey, filed on April 1st, 2019, the appellant stated that Ms. Roll came in to do something for her niece. And while she was there, Ms. Roll told her that she wanted the upsell and logged into her profile so that the appellant could enter the upsell on it. The appellant stated that after the Air Canada guest checked in, she posted 6 upsells using Ms. Roll's profile so that Ms. Roll could receive the commission. The appellant also stated, quote, as a manager, I do not get commissions on the upsells, and I knew if I gave it to Kira, she would give me a portion of the commission, end quote. At the end of her statement, she sought to change her statement slightly by saying, quote, I want to clarify that Kira would not directly give me a portion of the commission she receives, but that she would return the favor with a friendly gesture, like a small cash taken at a later date, end quote. Ain't that the same thing?
It's the same thing.
The appellant, under cross-examination at trial, claimed that the contents of the written statement were not her words, but were the security officer's interpretation of her words, and that she did not agree to the contents of the statement. However, the learned judge was not obligated to accept her changes to her evidence as truth. As a manager, the appellant's employer would have reposed a certain level of trust in her to carry out her duties with skill and integrity. It defies logic that the appellant's assertion that she was not aware that she could only give her upsell to another person if that person was on duty could be considered as credible. As found by the learned judge, her conduct raised issues of both dishonesty and a loss of trust, both of which are essential components of an employee, especially a managerial employee retaining employment. I accept Ms. Major's submission that the appellant failed to properly plead her claim that her suspension without pay was a breach that went to the root of her contract. In any event, the evidence is that she did not accept it as a breach and reported for work. Finally, the evidence from the respondent, which seemed to have been accepted by the trial judge, was that the clause of the industrial agreement, which allowed such a practice, continued in operation after the expiration of the agreement. And the appeal was dismissed. Yep,
Yep, I got it. Thank you.
got it. Yeah.
Curious, are there any cases that that you gave? I didn't read through all of them. I just read through mine and one or two others, but are there any that that were overturned?
Yeah, there are some. Yeah.
I mean, that you gave us, I'm saying.
No.
Okay.
I don't.
I think
But-
those would be interesting versus all of these that are still in the same line of upheld.
Okay. Yes.
Just to have
that
some diversity, Miss Archer. you know,
Huh?
Just to have some diversity versus seeing the same,
Okay. Well, it depends on what goes to the court, but let me see what I can come up with for the next set that I send you all. How about that? I'll try
I don't
my
know. Is
best.
anyone else interested? If I'm the only one, I'll
No,
yield.
no.
No, that'll be good.
That could be interesting. I agree.
Let me see with this one here. Hold on.
Let's look him up, Louis versus Patrice Ferguson,
You gonna do that one now?
if you don't mind.
Yes, go ahead.
Okay. This case is Commonwealth Brewery versus Patrice Ferguson, was based on wrongful dismissal, unfair dismissal. The crux of the case, I think, revolved around the term manager and supervisor. So let me get some background. Patrice Ferguson was employed at Butler and Sands in 1991 as manager in the computer department. Now, of course, Butler and Sands is the predecessor to Commonwealth Brewery. When she performed in this role, she performed managerial duties. She had staff, and she, based on the information, she had supervisory duties. Then in 2002, Burns House purchased the company, and Miss Ferguson was then placed in the business analysis department. Now, her managerial duties remained, even though this position was less than the one that she held previously. Continuing in 2007, Mrs. Ferguson was further transferred to the accounts department, and this also was a lesser position. However, Mrs. Ferguson, in meeting with HR, wanted to ensure that she continued to hold on to the title of supervisor and manager. And so HR made her feel that her term, the title was not in jeopardy, and that yes, she still was in a managerial position. And then fast forward to October 2016, where Ms. Ferguson was presented with a new contract where she was demoted to warehouse clerk. So of course, this position now means that Mrs. Ferguson is a line staff and is no longer a manager. Now, let's see if I can make sure that I have all of the context. Now, despite being this warehouse clerk, Ms. Ferguson's duties and responsibilities still included supervision and responsibility of 5 employees. She also attended managers' planning meetings, and in the absence of the warehouse manager, she performed his duties as well. In 2017, Mrs. Ferguson accepted an appointment to the position of raw materials warehouse coordinator, which was a step above a warehouse clerk. And so in that role, she also had responsibility for staff, and she also did managerial or supervisory duties. Her title, however, was still warehouse coordinator. Now, Mrs. Ferguson unfortunately was terminated after 28 years in the company, and she was given notice pay of $1,600 to $1,600.88. And then she was paid severance pay based on section 2029 1B2 of the Employment Act. Now that section that refers to severance pay for line staff. And that is where Mrs. Ferguson had an issue, because she felt that she should have been paid severance pay based on the supervisory or managerial position. Commonwealth Brewery disagreed with her and or disagreed with the ruling that she should be paid as a supervisor. Now this is where I got a little confused, because the encountering Commonwealth Brewery referred to a case of Durand Cunningham. They felt that when the vice president of the Court of Appeal gave the ruling, that she should have stuck to the decision that was made in that case. I didn't understand what that decision was. And I was reading to try to figure out
And Dion, wasn't this case stating also that she still continued to perform the same duties?
Well, similar, not the same duty, but similar duties that the
Well, that's
duties
what I
that
mean.
were, yeah,
Similar under another area, so still,
but still
the part.
supervisory duties.
right, without the title.
Correct. So the decision that was made was that I think from what I'm understanding is that they agreed with her. Yes, she should have been paid as a supervisor. However, Commonwealth Brewery says no, based on this Durand Cunningham and Bahamar case. No, she is not a supervisor, and she should not have been paid as, and she should not be paid as such. So the ruling then further disagreed with that, stating that there is that this Durand Cunningham case was based on a law that was repealed. And so the Employment Act, there is no definition of what a manager or supervisor is.
Correct.
And so the vice president then had to use the dictionary definition of that term. And based on the dictionary definition.
Stop right there. Remember in Unit 1 when I told you that when there is a law, the judge interprets it based on literal rule?
Yes.
Okay, so that's what the court is doing.
Okay, so that's what that was. Okay. And so based on that, they interpreted that the duties that she performed, yes, constituted supervisory and managerial, and that, yes, she should be compensated based on the duties and not necessarily her job title, because that is what Commonwealth Brewery's argument was. Her title was warehouse coordinator, which is not a manager or supervisor. But no, the ruling was, we're not looking at the name or job title, we're looking at the duties that she performed, and based on that, she should have received compensation. But one question, the appeal against Commonwealth Brewery was dismissed, no order as to cost. What does that mean?
No additional amounts.
So does she get the $20,000 that she was looking for?
Uh-huh.
Okay. All right. Okay, so was that clear? Did everybody understood the case? Where's Mud? Any questions?
Yeah, sit down and read it. Because I mean, because I've read it, I know what you're saying. But if you haven't read it, you have to sit down and read it.
Okay.
So if they haven't had the chance to read it,
then it'll be, yeah.
And they have.
But Miss Archer, if we read it, we may not understand it. Help.
To me, it was clear. To me, the case was clear because the only thing that I was not clear on was what exactly is the Durand Cunningham, what is that ruling? There was nothing in here that states exactly what the court meant.
Oh, but
You understand what because that is what Commonwealth Brewery is using. They're saying that the judge should have followed the decision that was made in the Durand Cunningham versus Bahama case. But I was reading and I'm trying to understand what was this decision? How did they?
It gave the definition of managerial versus supervisor.
Okay, they clarified what a manager and a supervisor
Yeah.
was. But there is nothing in the Employment Act that states that.
No. And then you couldn't rely on that. Remember when I spoke about law, when I say decisions that are made from the lower courts, I mean, on the higher courts are binding on the lower courts. And then I said that decisions that are made in other Commonwealth jurisdictions are persuasive. But in this, that case gave the definition, but that case was based upon the legislation that was repealed.
Right.
So you can't refer to that case.
So they had no argument because there is no argument because that case does not, or the decision or the law or whatever surrounding that case no longer applies.
Exactly. Isn't that embarrassing? Let me see who represented them.
What is Audley Hannah?
Audley Hannah, yeah.
With Keith Major.
Mm-hmm.
I don't know Audley.
Yeah. So again, you see, don't forget now, when you bring your case before the court, whether it's a tribunal or the Court of Appeal or the Supreme Court, your reliance is on those in that profession to bring your matter before the court for you to win. And you can see sometimes how some people lose.
Yeah, but I could see I could see how she won, but that was a stretch to say that she was a supervisor manager. I think she got lucky based on the fact that that law was repealed.
Yes. If it wasn't, then she wouldn't have gotten it.
No.
Mm. But whenever you see a legislation is silent, like how the EA doesn't speak to or doesn't give a definition, then it's courts to interpret. And let's say she didn't plead this, whereby she actually didn't state in I guess fully what she did, then she was going to end up just like in Brandley case.
No evidence. Yeah.
You have to plead it properly.
She did. Yeah, but she was, I think it's just egregious that she was employed for 28 years and they only gave her $1,600. I mean,
that's not funny. I thought she got 20,000. I thought you said she got 20.
Well, I mean, she had to go back to get the 20,000, but they were giving her.
Yeah, that was sad. They know that was wrong. Yeah. But it's interesting, Ms. Archer, you're saying it's how they're pleading it, which causes them to lose, which I get it. So is that why you're asking like who was pleading, who the attorneys were? Didn't properly bring it forth?
Yeah, well, well, on the opposite side now, if you look at the employer relied on that case as that was going to be the grounds for them to win and not pay.
How could they rely on a case that is defunct?
They weren't properly advised either.
But again, that reliance is based upon the attorneys. The company is not going to know which case to use.
That's true. Yeah.
They tell you what the matter is, and then they leave it up to them to present the case. And before they present the case, they decide whether or not there is a chance of success. But I mean, once they presented this and the judge realized that this definition was based on the legislation that has been repealed, that was it. Thrown out the window. That was it. Okay, anybody else? Kayleen? Because we didn't do Kayleen, eh? And then I'll end it for the night.
Okay, so that is me.
Okay, go ahead.
So it's Kayleen versus the Anglican Central Education Authority. So Mr. Kayleen was employed at St. John's College under contract. So he was claiming that they pay him for the damages in the amount of like 32,000 plus. And he's saying that the funds would have been earned under his fixed term contract if the Anglican Central Education Authority, or the ACA, did not prematurely terminated it. Now, this portion is unclear to me because it says that the tribunal makes no determination on the issue of unfair dismissal, as the tribunal has jurisdiction to hear only those matters referred to by the minister. Therefore, this decision pertains to wrongful dismissal and breach of the contract of employment only.
Right, those are sent to the Supreme Court.
Okay,
Mhm.
so
Remember when we did the process and we say that their matters are referred to by the Minister of Labor after some conciliation? Yeah, so it is a process.
okay, so Mr. Jervis was on a 2-year contract. And from September 2016, and at the end of 2017, he was then promoted as head of humanities. And then with this promotion, he was going to earn $34,000. So the situation was that there was a student in his class that while he was teaching, he got up without authorization. So Mr. Jervis threw a whiteboard mark at the student, and the student turned around and it struck him in the corner of his left eye. So it caused trauma to his eye. And then Mr. Jervis was suspended without pay, and then eventually he was dismissed. So during that time, Mr. Jervis, when the situation happened with the student, he escorted the student to the nurse, and he gave a report of what happened. He also gave a report to the principal. They also spoke about another situation involving Mr. Jervis with students when he was not authorized to take a certain number of students out of the classroom. So their rule is that for every 12 students, there should be an adult. So he took 23 students, and he was the only one that went on this field trip with the students. And what happened was that the bus overturned. So the principal, there was other situations. So the principal, in her recommendation to the Minister of Education, suggested that Mr. Jervis' services be terminated based on the—
Hold on. Don't forget now, they'd asked him to see the psychiatrist, you know.
Oh, yes, I missed that. So he was asked to see Dr. Timothy Barrett for a routine evaluation. Because what they're saying that because of the previous year, there was, because of the incident involving the 23 students. So then it went on to the part where they are, the principal recommended that they terminate him because of his history of incidents with students. And they're saying in which Mr. Jervis, the students came to harm, in which students and parents complained about his behavior. So in the case, Mr. Jervis admitted to throwing objects at the student. And they indicated that in the year 2001 to 2002, he was verbally cautioned by the senior master of his behavior, which he admitted. Then they said in 2014, there was a situation where he placed his hands around the neck of a female student. But he was saying that it was just a joke.
Yeah, but he had choked her. Remember, that's what she said.
Yeah, but he was saying it was like just a joke.
Yeah.
Like he was playing around.
Mm-hmm.
So it was 3 incidents. So the situation with the female student, where he choked the student, the situation with the bus, and then the 3rd incident with the marker. But the HR committee said that their decision to terminate him was not based on those other information because they were not privy to it, but it was only based on this last incident regarding the throwing of the marker. And that is what also the Director of Education, Ms. Davies, confirmed, that their decision to terminate him was based on that dismissal. So Mr. Jervis, he argued against the Anglican decision to terminate him because he's saying that his behavior was not gross misconduct, but it was an accident. And he was wrongfully dismissed because he did not have an opportunity to defend himself before the ACAH HR committee or to see the report written about his behavior. And then he also says that the ACA breached his contract of employment by not following the discipline matrix in relation to the penalties against him. So in the wrongful dismissal, the duty of the tribunal is to ascertain whether Mr. Jervis' employers believe honestly and reasonably that he committed a fundamental breach of his contract. And the tribunal also is stating that the onus is on the respondents to establish that there was just cause for the termination. Now, the employer is saying that, or the question was whether Mr. Jervis' breach was fundamental in nature or repugnant of the interests of the employer. Mr. Jervis argues that the accident was, I guess he was saying it was not intentional, but it was a mere accident. So there was the applicant, the witness, and the respondent. The tribunal is persuaded that the employer believed that Mr. Jervis' throwing of the object and hitting the student was intentional. But he is saying that he did not intend to hit the student based on trying to get the student's attention. But what the school is saying is that there's other means in which he could have gotten the student's attention. It could have been verbal, but he chose to use this marker. So this marker is used for the whiteboard. So it went on to say that the throwing of an object at a moving target that one is not certain where the missile will strike. There are vulnerable spots on the target, and the obvious risk is that the vulnerable spot could be struck. So Mr. Jervis admitted that his act was dangerous and it was unprofessional. Now, the school has policies based on violence and weapons, and they indicated that every year there's this handbook and there's a mantra, there's an anti-violence mantra that is repeated every day in the school by the faculties, the staff, and the students about physically, and was physically displayed in writing in every classroom. So the policy against violence is that that there should be no weapons. So they're saying that the purpose of it is to give students, parents, staff, and the community at large a clear statement concerning the school's position against violent behavior and weapons. And the objective is to ensure that the safety of the students and staff, their property, and the property of the school, to maintain a safe, supportive, nurturing, non-punitive school environment highly conducive to learning. And violent is any mean word, look, sign or act that hurts a person's body, feeling, or things. Now, that threw me off when they say violence includes hurting someone's feelings. But anyway.
Dealing with
so-
children?
I guess it's emotional.
Yeah. feeling-
Yeah, but anyway, that is interesting that they consider that as a weapon. But so they said a weapon can, so they further explained that a weapon on this policy, if it hurts any other person's bodily harm or property damage, it's not limited to belts, sprays, pens, pencils, scissors, or any other object, sharp object that is. So they're saying that a marker thrown at the student qualifies as a weapon where it caused bodily harm. So they're not disputing that in the case. They're saying the decision to hit a student to get his attention could be seen as violence under that policy. And if his intent was targeting the body or the feelings, I mean, they're saying that the intent was either to target the body or the feelings of the student. So, like I said, his option was to call the student by name or to walk over to him, but he chose to throw this object at the student. And in terms of, I guess, hurting the feelings, the Director of Education stated that that act could have also caused embarrassment to that child. So the tribunal found that Mr. Jervis acted throwing an object at a student with the purpose of hitting him to get his attention, which resulted in an injury to the student, was in nature an act of repugnative to the interests of the school, having regard for a list of factors. So some of the factors, they said that the duty and care of students in school, it's a duty of care owed by teachers and schools to principals. The adverse effects of such an act to the employer, which should manifest in legal, reputational, financial liability, repugnant to the ACAA's interests. And they're saying that Mr. Jervis, he was aware of this and the banning and throwing of objects, which was in the handbook, but, you know, he still did what was contrary to what the school, some of the school policies were. Now, Mr. Davis argues that, so let's back up a little bit. Mr. Davis, he gave report. So he gave a written report and he gave a verbal report. There were also the principal that gave a report. There were students that gave a report. So Mr. Jervis is arguing that he was denied the opportunity to defend himself because he was not given a copy of any of the reports submitted to the Director of Education. He was not invited with the HR committee or any member of that board to make a decision to terminate his employment. And the bishop failed to give him an appeal, as the bishop did not have a meaningful conversation with him and did not meet with him to discuss the report subject by the principal to the HR committee. But Ms. Davis is saying that the principal, who is responsible for carrying out the duty, they interviewed all the persons concerned, and whether or not Mr. Davis would have gotten a copy of the report, it wouldn't have contradicted anything he said. So whatever he said in the report and everything that all the witness, you know, presented the information, all of it was relevant. Everything was on the same accord. So they're saying that even though he is given the report, it would not have made a difference. So there's also the contract. There's a handbook. So they're saying in this handbook, it was not clear on what grounds Mr. Jervis was arguing because it formed a part of the contract of the employment. So I think this is what we read earlier, that if you have a contract the handbook is also a part of it. If all of that information is not in the contract, it can also be in the handbook, right? Or the policy. Correct?
No, the tribunal, they say they were satisfied that the handbook was not a part of the contract.
So, but but isn't he arguing that?
That's his argument.
Oh, okay.
They said it was just guidelines.
Okay. I see. Okay, because they're saying that that handbook is distributed to the staff at the beginning of the orientation. So he was made
Mhm.
aware of the policies in the handbook. Okay.
Right.
Okay, yeah, I see. The tribunal is therefore satisfied the handbook was not a part of the contract, but it was created to set guidelines in relation to how the ACA administration and faculty would perform their roles at school. Okay, so a
Yeah,
further,
the termination clause.
sorry?
Yeah, the termination clause.
Right, so the termination clause states that the authority may, in its sole discretion, at any time, summarily terminate the services of an employee if the employee shall any time neglect or refuse, or for any reason, and they, in brackets, exhibit ill health not caused by his own misconduct, become unable to perform any of his duties, B, fail to comply with any order of the authority, C, disclose any information respecting the affairs of the authority of any unauthorized person, or shall any manner conduct himself or herself contrary to the principles and morals upheld by the Anglican Church and its school system, or behave in a manner repugnant to the fundamental interests of the Anglican Church and the school. On summary dismissal under paragraph I, all rights, benefits, and advantages of the employee's appointment with authority shall with forth cease. Now, it states there's a matrix. So they says corporal punishment or misconduct, which is hitting, slapping a student. The first violation is immediate suspension without pay. The second violation is termination. And then it says throwing an object at a student, keys, chalk, ruler. It's immediate suspension without pay pending investigation. Now, in his case, I'm wondering if he is under the impression that he was under the clause that he threw an object. He was suspended without pay, but there's nothing that speaks about that second violation.
Agreed.
Okay.
Mhm.
So the question is in penalizing Mr. Jervis for the admitted breach, was the ACA confined to the matrix, or could it have resorted to the termination clause? According to the matrix, if a teacher threw an object at a student for the first time, he would be immediately suspended without pay pending an investigation. This occurred as the principal complied with this guideline and suspending Mr. Jervis immediately to carry out the initial investigation. Now, in summary, the tribunal dismissed this application because it says at the time of the dismissal of Mr. Jervis, the ACA held an honest and reasonable belief on a balance of probabilities that Mr. Jervis committed gross conduct. They further believe that the ACEA and Mr. Jervis had engaged in gross misconduct based upon sufficiently reasonable inquiry, which, coupled with Mr. Jervis' own confessions and consistent reports from other relevant persons, revealed the absence of any defense and any dispute as to what occurred and why it happened. And the impugned act of Mr. Jervis were in nature of being repugnant to the fundamental interests of the ACA in the circumstances of the case. My thing is, if I understand it was misconduct. But if we are looking at the matrix,
Mm-hmm.
it doesn't speak about termination. So is it that if it's in the matrix, can a person be terminated based upon what is in the handbook or on the contract or any other clause there is?
Yes. So
So-
the committee said they looked not only at the matrix, but they looked at the termination clause.
Okay,
So it wasn't just the matrix. And they didn't have to put in all of the egregious conducts that he had performed in the past.
yeah, right, because they're saying they weren't aware of it. So they were only aware of this last situation that happened, but the principal's recommendation was based on a series of events that took place over the course of the year between the parents and students.
Mm-hmm.
And that was her recommendation in terminating his contract.
Yeah, he should have gone to see Timothy Barrett.
But okay, so when I first started, I am still a little unclear of this part on, okay, so in a case like this, you indicated where it says the tribunal makes no determination on the issue of unfair dismissal. They only have jurisdiction to hear those matters referred by the minister. So could he have taken this to a higher court?
Yeah, he'd have gone to the Supreme Court,
Okay,
but it wouldn't be on wrongful dismissal.
he would have taken it to the Supreme Court for the money, he
Unfair.
was saying that.
He would have gone on unfair dismissal.
Oh, okay. Okay.
But would you look at how he had 3 incidents, right? They only was
Mhm.
focusing on the last one when he
Yeah.
threw the object at the student, right? To me,
Uh-huh.
if he had gotten his psych evaluation, it
Mhm.
would have helped him.
I don't know why they went that far. He should have been dismissed after the
After the
the
second
bus-
one, in
the
which.
first one.
Yeah,
But it seems like it was just maybe verbal warnings that he got. And I guess this was the last straw.
yeah, the 3rd one is it.
Yeah.
I thought you guys were saying he did see Timothy Barrett, may he rest in peace. He just,
He was
if you guys don't
referred.
know, he just passed away within the last month. But
Yeah.
Yeah.
he did indeed see him.
No,
No.
Oh, it was just recommended for him.
mhm,
Yeah.
Okay, gotcha.
yeah, and him and within himself knowing that that is his 3rd incident,
Mhm.
he should have gone.
Yeah.
I actually know Mr. Jervis because my
What?
cousin went to St. John's.
Oh my
And-
God, we should not have talked about the man.
And my coworker was at school at the
I
time
know
of the
him.
incident.
I know him as
and,
well.
and actually
know it.
he was that playful. And so really, he really didn't intend to, hit
I
the
beg
dog,
to
'cause
differ.
that's just him. That was just his attitude, really.
So
It
I
was
guess
just
that's-
unfortunate.
Yeah, I guess that's what he said when he actually choked the student. And he said he made the comments, you could have done better. You can do better than this. I read it as if maybe the student was like a really good student. And whatever happened, he was just joking and like, you could have done, I'm expecting more of you. Like if you're saying that that's his playful spirit.
Yes, that's how he was.
Yeah.
And that's the same thing my colleague at work said. I mean, she was saying that there was no malicious intent, but nonetheless, I mean, it shouldn't have
Yeah.
happened.
It shouldn't have happened, yeah. Yeah, there's certain things you just don't do because you see the child took it home to his parents.
Mhm.
Yeah.
Yeah, and they took a different view.
Yeah, there's a very thin line
Mm-hmm.
between that relationship.
Yeah, between parent and between teacher
Yeah.
and child,
Yeah.
because that could have moved into something else as being
Mhm.
what depends on where you touched.
Yeah, because I know there was an incident at our work. There was staff and there was a manager that jokingly made a comment to the staff. I don't remember exactly what it was, but like you can make a joke to another employee or other employees and they took it very lightly. But this one, he felt that it hurt his feelings.
Mm-hmm.
So he escalated it and requested like an apology. So I don't remember. It was like, because everybody was like really surprised that he took it that way. But, you know, he made the comment that, I guess like there's a thin line. You're a manager and I'm a staff. So, you know, we're not on that same level where you can joke with me. My peers can joke with me, but, you know, not you. So I guess in this same case, you have to be careful how you're dealing with persons.
Okay, paragraph 26. Paragraph 26 says, but for 25, it is trite law that a breach of a duty of care is negligence. Further, gross misconduct can manifest in any of two wrongs: deliberate misconduct or gross negligence.
Mhm.
Tribunal finds that Mr. Jervis's act of throwing an object at a student with the purpose of hitting him to get his attention, which resulted in an injury to the student, was in the nature of an act that is repugnant to the interests of the school, having regard to the following factors. One, the duty of care owed by teachers and schools to pupils. And you'll do that in the next module. It speaks about being an employee and having a duty of care. Reasonable parents take responsible steps to look after the health, safety, and welfare of their children. 2, adverse effects of such an act to the employer, which could manifest in legal, reputational, and financial liability, is repugnant to the Anglicans' interests. Because remember now, the school is looking at what's the risk. And if
Right.
they're going sued, then it's a financial burden on them. 3, the fact that Mr. Jervis was aware that the school specifically banned the acts of throwing objects at students and hitting students in the face in his policy handbook, and condemned, quote, any mean word, look, sign, or act that hurts a person's body, feelings, or things, end quote. 4, the fact that Mr. Jervis was aware, based on his admitted past acts of throwing objects at students, that it was prohibited behavior, and he was specifically warned by a senior master of the school not to do so again. The fact that as the teacher in these circumstances, Mr. Jervis was charged with the responsibility to engage in exemplary conduct before his pupils and not to engage in conduct which might cause students themselves to disregard the school's policies as propounded by the Anglican Central Education Authority. And this was reflected in another part of the Anglican Central what they call Education Authority's faculty handbook under the Code of Ethics.
Yeah.
Yeah, so it may have been him in his nature to be fun and throw things, but he violated their policy, general policy, and code of ethics.
Yeah. Mhm.
On more than one occasion.
And more than one occasion. And then when he put his action into the matrix, he violated that too. They were going to terminate him.
So if if he had seen Dr. Timothy Barrett, what would that have done?
Bard may have said that he had a condition.
So if he had a condition, would they,
Got to look in
they
that.
would put him on, not like, maybe a temporary suspension with pay?
Yeah, he might have. Tell him he needed the Bard may have said he needed a couple sessions.
Mhm.
And then he probably would have been the one to say that his actions are not intentional. This is him by nature. He's aware of, and he's gonna have to do some therapy. And instead of putting him in the classroom, they might have put him in and give him an administrative role.
Yeah.
But he needed someone to be on his side to speak to him, of him, and
Mhm.
why he was doing what he was doing. But the pop of the bus, I don't know how he was going to explain that.
Yeah, because they said he blacked out of the wheel.
So something is wrong.
Yeah.
Something is wrong. All right, ladies, that's it. For tonight.
Very interesting.
Thank you.
Very, very interesting segments. I never did got the documents, by the way, but I'll reach out
What?
to Mr. Pratt.
No?
No, it's just still the link for the Zoom meeting, but I'll reach out to him tomorrow and see if he can shoot it to me, because I really
Okay.
want to read up
Okay.
on these, yeah. So you have me for next week then?
Yes, my
Next week,
dear.
session.
All those who didn't present tonight will present.
Okay,
Yep, I'll send you.
Okay.
You send it early so I could go through.
No, it'll be early because it's gonna, I won't have you all until after midterm, you know.
Oh, okay. And midterm is March 15th, eh?
Mm-hmm.
Okay, excellent.
Yep, and I'll see if Ms. Dorset wants to write it. If not, I'll write it for you,
Okay.
if she wants to. I'll see. I'll double check with her. All right. So thank you very much.
thank you.
Time we'll
Thank
start.
you.
Yeah, before we begin, we'll do Joycelyn. And then we'll go into the new cases after we finish the chapter.
Okay.
Then I return. All right. So good luck on your midterm.
Thank you.
Thank
Yes.
you.
And oh, before I forget, by weekend I'll have the office send you your capstone.
Say
Send
it
us to
again?
what, sorry?
The capstone.
Okay,
That's a research paper.
okay,
Don't worry, it's gonna be interesting.
okay.
Yeah, I can just give
Ms.
you one
Archer,
search, or I can give you like 2 scenario questions, but I prefer to do the research because it's going to be relevant to the HR role.
Okay.
Okay.
okay. A question for you, Ms. Archer, before you go,
Yeah.
please. I wondered whether, are these recordings available?
Yes, they should be. Yeah.
Okay,
Just ask Mr. Pratt. He'll give you the link.
okay, perfect.
Yeah. Not a problem.
Thank you.
Okay. All right. So I will see you all in a few weeks.
Thank you.
Okay. All right.
Okay.
Bye
Good
bye.
night.
Bye bye.
Good evening, everyone.
Good evening.
Good evening.